Hello everyone, we are going to start the chapter 1 of International Commercial Arbitration. When private parties, we are pertaining to buyer or seller or both buyer or seller or supplier. And business to business, when they encounter a dispute or arguments, they have a choice on how to resolve or settle for a solution. Either go to the court, solve by themselves, or look for another party who will mediate with them. International commercial arbitration is an alternative dispute solution for resolving issues between parties. To avoid litigation in national courts, they address the problem. Today, let us understand how ICA, that is the acronym for International Commercial Arbitration, um, let us try to understand how ICA had started. Let us define some words and identify different kinds of disputes, arbitration, and resolution. 2,000 years ago, trading is the oldest profession of our ancestors. Changing textile to banana, iron to gold, clothes to minerals, and minerals to pottery. Those are the trading activities that were being conducted in the old times. Let's say, for example, Assyrians, they traded to ancient Egyptians. For Chinese, they traded to India. Greeks, they traded to Romans. And of course, humans have emotions. Transactions were not that perfect. Due to circumstances, dispute rises. So what are the common disputes? The common disputes are number one, delay of delivery. Number two, defaulting payment. Number three, breach of contract or violating the contract terms. Number four, unequal value of goods. As I had mentioned, due to personal differences in business, trading tends to have a problem that arises to dispute. Number one, if the nature of dispute is within the contract or failure to comply with the conditions and the terms of contract, therefore that could be a contract dispute. If one party intended to do wrong or negligent wrongdoing in the business relationship, we call it tortious interference. Next is dishonesty or fraudulent business dealings. We call it racketeering. And if the dispute arises because of failure to pay goods and services accordingly, that is financial disputes. If in case that the stakeholders or the company itself breach their duties or fiduciary duties or had a conflict of interest, we refer it to corporate disputes. Normally, the common disputes arises from product delivery delay, malfunction, and unpaid terms. What are the causes of financial dispute? Number one is payment terms. They do not follow the right date or either they do not pay the right amount. Secondly, we have the letter of guarantee. It's not acceptable or they fail to present a letter of guarantee. Third is foreign exchange. The value of dollar is different from the value of yuan of won, and of course it will reflect to the financial statement of the organization. Fourth is the documentation error or discrepancies. Letter of credit. Letter of guarantee, forwarded contracts, there are some informations that is not relevant or accurate, or sometimes the information is not authentic. That could be some of the causes why financial dispute happen. But nowadays, it changes. WTO recorded a survey result from 392 respondents from 92 countries that 90% of disputes arises from contract agreements and jurisdictions, and 80% concluded patent-related issues, that is for international property rights. Let's move on with the causes of contract dispute. Okay, particularly if one party, okay, is not going to fulfill the duties and responsibility therein, the contract dispute rises. Uh, there you could see the delays on contract completion because in the contract there is a particular date wherein you have to fulfill the obligation. Secondly, modification without mutual consent, meaning one party, the buyer or the seller, change a particular condition in the part of contract without informing other party. That could be a subject for a dispute. Third, verbal agreement failure. Okay, verbal agreements is being honored in other agencies. But of course, that's what we call palabra de honor, word of honor, word of honor. Okay, so if they fail to fulfill their promise verbally, that could be a subject for it will cause dispute. And the last one is non-shipment of blockage at airport. Okay, or it means that the item was not being delivered due to some circumstances. Note, to solve this dispute, it will be processed through arbitration or litigation. Again, arbitration, you are going to settle the dispute out of the court. Okay? For litigation, you need to find a lawyer, you need to present yourself to the court, you need to present an evidences, that is litigation. Let's clearly define what arbitration is. Okay? Arbitration is a process by which parties consensually submit a dispute to a non-governmental decision maker selected by or for the parties to render a binding decision resolving a dispute in accordance with neutral. When we say neutral, both party, buyer, seller, or seller agreed, okay, to the process that must be undertaken. And this must be adjudicatory. When we say adjudicatory, you still follow rules and regulation. And the agreements are binded by common law. Alternative dispute resolution is a collective term for the ways that parties can settle disputes with the help of third party, meaning you're going to settle dispute out of the court. And you you know what, in our country we go initially if there will be some dispute happen in the community or in business, okay, wherein the business is located, we initially go to community center. Okay, and that area, the officer, we call it community captain or barangay captain. Okay, they're going to settle dispute within the community. If the community leader, okay, failed, okay, to settle the dispute, that could be the only time that we are going to proceed to police and file a case in the courts. There are different forms of alternative dispute resolution. First, mediation. Okay, this is a process wherein someone who can intervene, okay, in a dispute order. Secondly, expert determination or through consultation. Okay, both parties going to choose or select a specialist. Okay, a specialist not related to seller, not related to buyer, but of course, as someone, okay, who is who know, okay, what to do with the situation, and if the situation is related to property or a machine, okay, so they could be a big help to resolve the problem. Mini trials, okay, you can go to a city hall or community center. Next is a final offer arbitration. So in this particular way, both party, the buyer and the seller, will be given an opportunity to present their suggestion or suggested solution to solve this dispute. And there are also other form of alternative dispute resolution like community dispute resolution program and the neutral evaluation, meaning they just going to settle it on their own. For you to be able to understand the nature of international commercial arbitration, let's try to identify some dispute in international setting. The first one is the dispute between the Brazil Canada aircraft dispute. This is the issue about government subsidy. Canada, the Bombardier Incorporation complained to World Trade Organization, and World Trade Organization is the one who process, entertain, and arbitrate the dispute between one country to another country. They have a particular committee. They call it WTO Arbitration Committee. Anyway, um, this Bombardier complained to WTO that Empresa Brasileira de Aeronautica. Okay, it's kind of a difficult word, Brazilian word. Okay, and okay, the Bombardier is complaining to WTO about Empresa receiving subsidy from the government because in international law, in trading policy, there is a policy that government should not subsidize in exporting uh, industry. Okay, so they are not allowed to support or to subsidize directly. Okay, the exportation, but Canada claimed that Brazil illegally received an export subsidy, and WTO arbitrator is currently considering the correct level of sanctions Canada could levy against Brazil. So this is under negotiations. We are still in the process of settlement. So if Canada would like to pursue in litigation, okay, definitely they're going to process it in the international court. But they don't want to consume a lot of money and time about it. That's why they try to settle it through arbitration. Secondly, McDonald brand logo versus Europe Mac Coffee. There is an international law that you could not copy the name or even just the sound like of the company brand logo. Okay, that is being registered in international property rights. So this is the issue of trademark rights. I think what happened with this dispute is that Europe had Europe Macopi had paid damage to McDonald brand logo. That's what happened with this case. And lastly, I think just recently, Apple versus Samsung. Okay, Apple claimed that Samsung had stolen iPhones designed with its smartphones. And I think it took 7 years for the litigation, but I think last year they had decided to settle the dispute through arbitration. And Samsung agreed to pay a tantamount, a huge amount of money to Apple. What is arbitration clause? Okay. This is a clause in a contract that requires the parties to resolve their dispute through an arbitration process. What is the connection of this with the arbitration? Okay, you know what? When you write the contract, there is a particular conditions or a part of contract stated clauses, a jurisdiction in which if there will be some dispute that will happen, which kind of jurisdiction to follow, which kind of law, what law, okay, they are going to follow. Okay, so it is a part of a contract conditions and provisions that give rights and option for both party, okay, to settle dispute either, okay, in arbitration or in litigation. If it is written there at arbitration clause, meaning both party agreed if there any dispute arises within the transaction, they are going to follow arbitration process. And if the dispute happened from one country to another country or between one country to another country, therein you could see that international commercial arbitration will take place. Okay? The World Trade Organization will gonna facilitate that if they asked WTO to resolve the conflict, okay, or they could use some rules and regulation of international commerce, okay, international commerce rules and regulation, or they want to follow the UNCTAD rules and regulation. Those are some of the guidelines and the regulations wherein if both parties are foreigner or in different countries, okay, and the transactions had been failed and they want to resolve the dispute, okay, they could go to ICC, they could follow the ICA, they could follow UNCTAD, they can follow WTO rules and regulations. Is arbitration legal or not? Of course, remember the contract, okay, to take effect, it must be signed and sealed by a lawyer. Okay, so arbitration is legal process because they follow legal rules and regulation. And however, they were given a choice to settle the problem in easy and convenient way. They followed the contract. If the dispute happen, both parties will agree just to follow the contract or not follow the contract. Okay? And that could be an arbitration agreement. If they need to follow some institutional rules, okay, if they don't want arbitration, okay, they could still go to other institution, okay, government, okay, as I had mentioned. Okay. Next is they can follow also the rules and regulations initially also of by national legislation. UNCITRAL, UNCTAD, WTO, those are some of the legislative, okay, the rules and regulations. Next is international conventions. Okay, New York Convention is the most important instrument that regulates recognitions and informants of foreign arbitral awards. Okay, so they follow these kinds of rules and regulations. Here are some of particular agreements for arbitration. If both party had decided that okay, let's just go to arbitration. But before you go to arbitration, you have to analyze the dispute. Okay, these are the main elements. Okay, so both parties should agree they want to go to arbitration. Why? Because some of the complainant especially they want if they have a personal interest and they know that they're gonna win the the dispute, they're going to take advantage of that. But of course, that's why arbitration is being created so that both party will benefit and both party will gonna be in a position of win-win situation. Okay, so initially, both parties should agree that they want to go to arbitration. Secondly, is what to arbitrate, why they need, what kind of dispute okay they need to resolve. Okay, third, both parties should agree what kind of arbitration rules they want to use, and that could be the part of contract. Number four is the arbitral seats. So this is the domicile of arbitration, and unless we say otherwise, this is the procedural law, okay, the process to follow. Next is selection of arbitrators. Okay, so these people will hear your dispute. Okay, so as I had mentioned a while ago, either they are specialists or a mediator or a community leader. So yeah, both parties should select. Okay, and initially there are some attributes that you have to follow when you want to select an arbitrator. And which language to use, of course, if it is international. Is it in English? Is it in Korean? Is it in Vietnam or Chinese? And if you allow interpreter, something like that. And the last one is the choice of law. Okay, the choice of law. Okay, so here are some of the applicable law. We have the merits, arbitration agreement, the procedural issues, and the choice of law itself. But this particular law, they are of course available. They are the national law. Okay, there are national law that you have to follow. Example, if one party did not pay the right amount, okay, there will be a Republic Act for that. Okay, there will be estafa. Okay, estafa not paying, not paying the right amount of money. Okay, so there are several law that should be mentioned in arbitration clause or in the contract. Okay, it's very important that there will be a guiding law. Okay, the guiding law, of course, that will be the basis of decision making. Fair decision. Okay, remember, arbitration's objective is to put both party in a win-win situation. Remember also that ICA aims to promote easy manner or way of solving disputes. That's why it follows some principles. Number one is separability. Separability. Okay. This is an arbitration agreement uh, wherein the arbitration agreement is treated separately from underlying contract, meaning it separates contract conditions to arbitration agreement. Your condition during the arbitration is different from the condition that you have in the contract. Okay? The validity of the contract does not affect the validity of the arbitration agreement. Contract is a contract, then the rules and regulations in arbitration is also a different thing. It doesn't conflict because when you create an arbitration agreement, okay, um, it should be within the scope of the dispute, not to negate what is the existing condition in the contract. Okay? And Secondly, policy considerations. Not all disputes are needed to arbitrate. Sometimes what is obvious should be followed. Okay? You have to take a look. Do you really have to arbitrate the dispute, or the problem is just that they have to pay the money, and then they should just pay the money? You don't have to go in the court. But the main thing is that if the party really doesn't want to pay the amount, that could be the time that the complainant could make a drastic action. Okay? And also, if the dispute, okay, uh, is relevant, okay, to the contract, okay, that also considered to be the characteristic of dispute. Is it arbitrable or not? Okay? And if you think that the dispute could not be resolved by arbitration, you don't have to do the arbitration. You can go directly to litigation. Why it happened, Professor? It happened because sometimes number one factor is one party doesn't want to agree with the arbitration agreement. And another factor is that a complainant party want to take advantage with the situation. And another factor could be there will be no available mediator, or both of them doesn't want to go with the arbitration. They just really want to follow the national law. Okay, that could be just some of the principles of ICA. So as we go along with our discussion, um, we are going to understand clearly the other aspect of international commercial arbitration. Remember, jurisdiction of a judge or arbitrator to settle the dispute is an exclusive one. Either the judge or party, okay, dispute must be submitted to arbitrator. You call the arbitrator, you follow the arbitrator. There must be a valid agreement for arbitration. The court will decide to who arbitrator to prevent from going forward. Normally, the court also entertain some dispute or some complaint. They file some lawsuit. Okay? But the initial advice of the court is try to find a mediator or arbitrator if you can settle it out of the court. So here you could see some of the difference between arbitration and litigation. Okay. For arbitration, in terms of proceeding, it is private. Only the complainant and the complainee, okay, the 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 both party should be present during the proceeding. But for litigation, it's in the court, it's in the courtroom, it is public. Okay? Sometimes the media is available, is present. In terms also, the proceeding is civil and private. Okay? But for litigation, civil and criminal. Okay? While you are being accused of a uh, particular violation, you are being considered as criminal. That's why it's really kind of complicated. It's kind of horrifying and stressful if you're going to the court, okay, especially if you are the one being complained. In terms of evidence, in arbitration, limited, okay, you can present evidences in a limited way, a limited number, but for litigation, the more evidence, the better. Okay? And how about the arbitrator or the judge selected? Arbitration, they have the right to choose, okay, who will be the arbitrator. But the litigation, they are going to appoint a judge, okay, and parties have limited input. They could not say to the judge, would you please process our case in court number 7, office number 7, something like that, Okay. In terms of formality, arbitration is kind of informal because you're just going to sit in a room and then talk to one another. But for litigation, there are a lot of people, staff, witness, the attorney, the police, or the marshal, or the security, okay, during the hearing or the process of solving the case. Appeal available for arbitration usually no appeal. You don't have to appeal because you're going to settle the issue right in there. But for litigation, if the court already made a decision, okay, there is a chance to appeal to the decision of the judge. In terms of use of attorney, arbitration, you don't have to. It's the discretion of the party. If if one party wants to defend themselves by an attorney or a lawyer, okay, they can do that. But it is not necessary. But for litigation, there is an extensive use of attorney. Okay? And of course, if you have a lot of lawyers, a lot of money as well, you have to spend. What about waiting time for the case to be heard? Arbitration, as soon as arbitrator is being selected, okay, you could proceed with the hearing. It is short. But for litigation, you have to wait for the case to be scheduled, especially um, in the court. It's not only commercial dispute they are going to settle. A lot of criminal cases they need to schedule. So you have to wait until the schedule made available for both parties or for the complainants. And lastly, the cost. Arbitration is you only pay the arbitrator or the attorney if there will be some needed attorney or a lawyer. But for litigation, you have to pay court costs, lawyer fee, and it's really costly. You have to go to the coffee to meet. Of course, you have to pay the food or the meal for the lawyer, for the witness, for the documents you have to present. Extensive expenditure that could happen for litigation. That's why uh, most of the time arbitration is being chosen to solve a particular dispute. Okay, here are also other options that you can use to resolve a dispute, either mediation, mutual evaluation, arbitration, or trial or litigation. Okay. So, what are the qualification of arbitration clauses? Okay, number one, you have to state the nature of dispute and the basis. Okay, is it valid or not? Is it the dispute really happened or you just one part is just making money out of it? So you have to check. Okay, and also another one is you must state what resolution you want. Okay, both party will be given a chance what kind of solution they want to suggest, okay, including monetary damage if that could be the claim of the complainant. Okay? So those are some of the qualification of arbitration clause. Okay. More so when two parties agreed to settle their dispute through arbitration, okay, so it must be neutral. Okay, it must be neutral. Okay, so as I had told you a while ago that the court, if you file a case to the court, they're going to suggest that you settle the dispute through arbitration first. And initially, through the arbitration, it is being settled privately. No public audience. It's only between the parties and the arbitrator. Okay. When Thus, arbitration is not appropriate. Of course, if the dispute is nonsense, okay, let's say he just stolen my boyfriend, no? I mean, if the dispute is not arbitrable, okay, or it is just petty thing, it doesn't damage B to the both party, okay, so the arbitration is not appropriate, okay, and also it is not appropriate when one party lacks a capacity. Okay, let's say Saudi Arabia, Iran, US, they have their own specific authorization. They have their own rules and regulations. So they don't subject for or submit for arbitration. Okay. And next is forcible action may be required. Let's say there must be a final rulings, okay, to be implemented. Let's say if it is criminal, if it is already a damage in monetary, and of course the complainant want to receive immediately the 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 money, okay, they're not going to proceed with its arbitration is no longer needed. Okay, there must be an immediate action. Next, okay, quicker and cheaper proceedings are available in court. Okay. Normally, when one party doesn't want to settle the dispute without the court, okay, that would arbitration is not appropriate. And of course, sometimes the dispute it could be easily resolved by available proceedings or by available rules and regulation that are implied, okay, that are implied. Let's say a party burned the whole building, okay. Of course you don't go with arbitration initially. The court is going to have a final decision about it. And take note, arbitration is not appropriate if it is more than two parties. Arbitration is involved only between two parties, not more than two. If it is more than two, they go to the court. Okay, and when this dispute should go to the court, or when this dispute have to go directly in litigation process, okay. Of course, if uh the award in arbitration is not valid, okay, complainant doesn't satisfy, or he thought that something uh, is illegal or not acceptable, okay, they can go directly to litigation. See, secondly, if the mistake is really serious uh, and also it really violates the fact, okay, or it really violates the national law, okay, or they had used the wrong interpretation of law, that would be a subject for the party to go directly to the court. And the last one is if one party doesn't want to follow or refuse to enforce the award, and then you can go to the court. I just want to show you the arbitration processes, how what happened in arbitration. They file a case, they select an arbitrator, and then there will be a schedule of preliminary hearing, and then also um, they're going to know what would be the proceeding. There will be some brainstorming, what documents to submit, then what could be the ground they're going to set. It's like an initial meeting. Then there will be a hearing where they're going to present their complaints and their claims. And then after that, arbitration is going to evaluate, okay, and here again some if there will be some additional information, okay, requested for both parties, and then they're going to proceed with the briefing, okay, and final arbitration. This is the arbitration process. Okay, so for the process, okay, initially you're going to file the complaint. Okay, either you follow up depending on the country which process they're going to follow. Okay, and that is the filing. Secondly, you're going to choose which arbitrator. Okay, and the third one is conducts a preliminary hearing with the parties. Okay, like brainstorming what is the issue all about. And then there will be some witnesses, okay, that will testify if the dispute really happened. And of course, information exchange and preparation. They're going to present their evidences. Then there will be hearing, testifying, then post-hearing submission. Okay, they're going to ask for some additional documents, okay, if needed by the arbitrator. And the last one is the award. The arbitrator is going to weigh the evidences presented, and the situation is going to analyze what really happened, and from that the decision will be given. Okay, remember, arbitration aims to create a resolution favorable for both parties. Okay? And I already mentioned that arbitration need a lawyer, not that much. Okay, it is allowed. Okay, but if it is not necessary, you don't have to bring a lawyer. Okay, anyone is entitled to have a lawyer, but it is not a requirement. Okay, so you could have an advisor, you could have a lawyer to advise you what to do. Okay, and of course, if you're going to get a lawyer, you have to pay them. That's why uh arbitration aims to avoid the cost of going to the court and the cost of paying or hiring a lawyer. Attorney is also a lawyer. Okay. How much is the cost of arbitration? Uh, you could see there only the processing fee, the filing fee, some administrative costs, some paperwork, okay, and then the cost of the arbitrator, either hourly or daily rate. Those are just some of the expenses, okay, that may incur for arbitration. Okay, so that is the initial overview of international commercial arbitration. To sum it up, international commercial arbitration is a process of resolving a dispute between parties, either buyer and seller, okay, from other country. Okay, Korea versus China, okay, or if the company is from Thailand and the other company is from Vietnam, okay, international commercial arbitration will take place, and it aims to provide a solution to a dispute wherein both party will benefit the result, or they will be in a win-win situation. That's for today, and see you on our next chapter.